Good afternoon, Madam Deputy Registrar. Would you please call the matter?
Thank you, Judge. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Barbados, judgment delivery in Consolidated Appeals, BBCR number 1 of 2024, Stuart Kenny Macmillan Harewood and the State, and BBCR number 2 of 2024 between Scott Colby Richardson Harewood and the State. The members of the delivery panel are Mr. Justice Anderson, presiding judge.
Good afternoon, Counsel.
Madam Justice Rajnathli.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Mr. Justice Burgess.
Good afternoon, Counsel.
And Mr. Justice Jamadar.
Good afternoon to everyone.
May we have the appearances, please? Thank you.
Good afternoon, Your Honours. Sathia Moore, appearing in association with Mr. Marty Garnes on behalf of the appellants Scott Harewood and Stuart Harewood.
Good afternoon, Your Honours. Romario Straker, Principal State Counsel Acting, appearing in association with Ms. Crystal Delaney and Mr. Neville Watson, Principal State Counsel on behalf of the respondent.
Good afternoon again, Counsel, and thank you for your appearances. We have arrived at a decision in this matter. The judgment of the court was written by our brother, Justice Peter Jamadar, and I will now ask Justice Jamadar to read a summary of that judgment.
Thank you very much, President. Good afternoon again to everyone. This summary, of course, is not a substitute for the judgment of the court. This appeal from Barbados is a consolidation of 2 appeals by Scott and Stuart Harewood, who were convicted of murder. The appellants were charged in June 2014. They were indicted on the 31st of August 2016, arraigned on the 21st of October 2020, and pleaded guilty to non-capital murder. On the 25th of March 2021, they were sentenced by the High Court. And in April 2021, the DPP filed for a review of the sentences, asserting that they were too lenient. The appellants, for their part, appealed, contending that they were too severe. 14 months later, on the 7th of July 2022, the appeals were heard. 15 months after that, on the 13th of October 2023, the Court of Appeal delivered its judgment, finding that the sentences imposed were not too lenient and dismissed the appeals. They therefore affirmed the sentences of the trial judge. The appellants were granted special leave to appeal to the CCJ, this court, on the ground that the Court of Appeal erred in law and/or in principle when they failed to reduce the sentences on the basis of delay. The appellants sought a reduction in their sentences on the sole basis of delay. I delivered the judgment or wrote the lead opinion for the court, and in that opinion held that while the appellants have clearly demonstrated significant and even unacceptable periods of delay, the totality of considerations is insufficient for the court to conclude that the impugned delay crosses the threshold to become constitutionally unreasonable or in breach of fair hearing standards. This was so as, 1, the appellants accept responsibility for part of the time lapse between indictment and sentence. 2, there was no official statement sought or reasonable opportunity given to the judiciary to explain delay at the appellate level. 3, the DPP has advised this court, and it has not been refuted, that during the period while the appeals were pending, the effects of the COVID-19 pandemic were still impacting the judiciary in Barbados and its Court of Appeal. And as well, that during that period, the Court of Appeal was not fully constituted, but operating with only 3 justices of appeal. And 4, any prejudice to or impact on the appellants resulting from the time lapses have not been demonstrated as rendering the court proceedings unconstitutionally unfair or unreasonable. The Court of Appeal, in the exercise of its discretion to grant constitutional relief, was not bound to grant the remedy of a reduction in sentence if there was a breach of the right to a fair hearing within a reasonable time. This discretion does not result in any prescriptive relief or remedy. A remedy upon finding unconstitutional delay must therefore be made on a case-by-case basis. Furthermore, although Section 18(1) of the Constitution of Barbados gives distinct and freestanding rights, these can be interrelated depending on the circumstances of the case, and constitutional analyses must be alive to these overlaps. Moreover, addressing the issue of delay requires a nuanced and multi-perspectival approach to judging. Among other things, both the impact of delay on an accused perpetrator and the interconnectedness and interdependencies of the criminal justice system as a whole are to be considered in a fair, reasonable, and balanced way. From the perspective of time standards, constitutional delay is not functionally the same as timelines, though it may be implicated by established time standards. Time lapses in court processes between certain milestones and events function purposefully, setting benchmarks. These can be mandatory or discretionary and include overarching time standards. Failure to meet these time standards is not presumptively proof of either delay or unconstitutionality, although they may be relevant considerations. Unacceptable delay depends on an assessment of whether the delay in all the circumstances is unwarranted, inappropriate, out of proportion, and/or reasonably avoidable. Delay may be unconstitutional if it is such as to render a hearing or court process unreasonable and/or unfair by failure to complete it within reasonable times. In cases of delay unrelated to delivering judgments, a broader assessment of fairness, reasonableness, and the accused's rights must be made. The courts must consider whether the delay is disproportionate, avoidable, or prejudicial to the accused. Both parties can present evidence on these points. Additionally, the accused has a responsibility to cooperate in avoiding delays in the legal process. Public interest and the rule of law also play key roles. The justice system must balance the rights of the accused with societal needs for accountability and the interests of victims. Judicial officers, like any party, are entitled to natural justice and to the opportunity to explain delays transparently. Furthermore, whenever there is judicial delay in court proceedings or in the delivery of judgments, there is a constitutional, ethical, and moral duty on the court and judicial officers to transparently, candidly, and openly explain the circumstances that have caused the delay. This court dismissed the appeal and made no order as to costs.
Thank you, Justice Jamadar. Are there any comments from counsel?
No, Your Honor.
Thank you.
No, Your Honor.
Thank you very
Mr.
much.
Chairman.
Thank you. Thank you again, counsel. So that all that remains to be done is to thank you again for your appearance and participation, and to ask our Deputy Registrar to close the proceedings.
Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochley. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess, and thank you, Mr. Justice Jamadar. Thank you to counsel, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you.